Welcome to our latest update brought to you by Clyde Co's employment team. This episode is titled Employer Update on Union Access Rights. In some sectors, trade unions have traditionally been very active, but the majority of employers will have had limited direct engagement with them. With changes to trade union legislation scheduled for October this year, organisations will need to consider how these developments could affect their workplaces. In this episode, we explore the upcoming changes to union access rights and the key points employers should be aware of. Hello, I'm Charlotte Stern, and today I'll be speaking to Stephen Miller and Stuart Healy, both experts in union-related law from our employment team. So, trade union rights are undergoing some big changes under the new Employment Rights Act. Today, we're focusing on the new right of access, and we think it could be a game changer. To set the scene, as things stand, unions have no free-standing right to enter workplaces. Access depends on employer consent, a voluntary or recognition agreement, or specific contexts such as accompanying an employee to a disciplinary hearing or grievance hearing. But following a consultation on the 6th of July 2026, the government has finally published its response and laid the finalised code of practice and supporting regulations before Parliament. And subject to approval, these all come into force on the 30th of October 2026, which is coming up really soon. So, what are the changes being introduced by the Act?
Well, hi, Charlotte. The Act is going to allow unions who have no existing relationship with an organisation a statutory right of access to the employer's workforce and workplaces, both physically and digitally. And if access isn't agreed, then there's a body known as the Central Arbitration Committee, who we'll be calling CAC, which is an existing statutory body that resolves collective disputes. Generally by facilitating agreement or making binding decisions if necessary. And it's the CAC which can determine whether access should take place and on what terms. And it'll apply the factors in the Act and in any secondary legislation which comes out.
So, Stephen, it sounds to me like it's a process that's allowing the unions to build their profile in workplaces, even if there's no pre-existing dispute or interest from workers.
That's exactly what it is, yeah.
And how do we think the unions are responding to this?
Well, unsurprisingly, Charlotte, unions are prioritising this right. And once implemented, we expect access rights to increase. The TUC, that's the Trade Union Congress, says the new right opens up ways to connect directly with workers and advises union teams to take advantage of this.
So, what's then the purpose about this, and what type of access can a union actually get?
Yeah, well, the right of access is going to allow unions to boost their visibility. It's going to provide a formal route for unions to secure access to workers and workplaces, and then potentially take advantage of the existing right to seek statutory recognition, which in turn will allow for representation and support, recruitment and organisation within the workplace, and if they're successful in getting statutory recognition, to facilitate collective bargaining. And it's important to remember that the access is not limited to situations where a union is already recognised and can arise without any formal union recognition process. And access, if granted, whether voluntarily or through the CAC, includes such things, obviously, as physical access to workplace. That would be the conventional route to access. But in a nod to modern times and communications, the unions will also be able to take advantage of digital access, including email and digital platforms. And they're also entitled to have direct communications with workers. And in the course of their communications, they can have meetings with the workers to support and represent them and promote the benefits as they see them of having a union recognised within their workplace.
And obviously, you can't then control what they're saying. So, how often could a union access a workplace?
Well, the answer is frequently. The code of practice indicates that weekly access will be considered reasonable, which may not be the most welcome news for everyone. However, you'll be relieved to know that private accommodation will be excluded, although hybrid residential working environments will fall within scope, subject to some safeguards.
So, we've looked at the purpose and what sort of access a union can seek, but who exactly can apply for access and how did this work in practice?
That's a good question, Charlotte. Any independent trade union can apply for access to an employer, but only to an employer with more than 21 workers in total. So small site within a large organisation may still be caught, and any agreement about workplace access will not last longer than 2 years. In practice, that means it's going to be pretty wide in its application.
And what happens if there's a dispute?
Well, as I said, that'll be referred to the CAC. And there are some limited circumstances in which the CAC can refuse a request for access. And the first two are probably the ones that could have been most commonly encountered. So an employer can refuse access on the basis it already recognises a different independent trade union representing more than one workers, or the workers are already covered by a statutory access agreement, which is in operation with another trade union. And so, as I said, those are the most common. But the next, which really conjures up the nightmare scenario, is the CAC has been given the power to refuse access to trade union if that access may jeopardise the health and safety of any person covered by that access agreement. Because it's always worth remembering that although you tend to think of access to an office environment, this is access to any work environment, some of which environments have lone workers and people who conceivably could be threatened by a right of access given to strangers. It's worth noting, actually, when we're thinking about this, that the right of access can't be granted for the purpose of organising industrial action. So at least there's a limit if there is access granted.
Thanks, Stephen. So what you're really saying is that whilst access rights are broad, they're not actually unlimited.
Technically, they're not unlimited. And I know you said earlier that once they're in, we can't control what they say. And I broadly agree with that. But you could have a case where if the trade union said something outrageous or defamatory, there's some way of controlling that after the event. But in practical terms, there's no restriction on what they can say once they get access.
And so what's the process for getting access?
Well, being a statutory right, it's possible to reduce this to the steps taken, and the steps are simple to understand. And if anything, what jumps out is not the step themselves, but the time involved in responding. So you get a union request to an employer. And once that arrives, the employer has to respond within 15 working days, typically 3 weeks, of course. And that's a really quick period of time, particularly for an organisation that's unfamiliar with the right or unfamiliar with working with unions. And if you don't have a complete agreement within that 3-week period, there's the legislation allows for a period of negotiation, which is a further 25 working days, 5 weeks. And again, that can pass quickly, particularly, as I say, if people are unfamiliar with the issues involved. And if at the end of the 40 working days access hasn't been granted, it's at that point that the union can take the complaint to the CAC. And the CAC will then essentially conciliate between the parties, allow for further discussions. And the CAC, as part of their statutory remit, have been told in determining complaints, they have to balance the policy objective of enabling union access. After all, that's the whole point of this, and avoiding unreasonable disruption to the employer's business or unreasonable facilitation obligations on the employer.
I think it's also worth noting that I think you've mentioned some of the circumstances in which the CAC can refuse access earlier, Steve, but also where there are competing or concurrent access requests. If that were to make refusal reasonable to help avoid multiple parallel access requests going on at the same time.
Yeah. And of course, this is what's going to happen because the unions are being handed through the statutory measure the ultimate recruitment tool. And an individual can only be a member of one union. And so there will be competition between unions to get access and to make the better proposition. And in those circumstances, as you say, the CAC would take that into account.
It sounds like really what you're saying is it's going to be quite difficult to block an access request.
I think that's the mindset that employers have to have, that although there exist these possibilities, that particularly in the early days when the right is just being tested, the CAC is almost certainly going to err in favour of allowing access. And as I say, the request is unlimited.
So, assuming now that you've got an access agreement in place for 2 years, what actually are an employer's obligations?
Well, if you've survived 2 years with the union in place, hopefully things are going smoothly. The code of practice sets out examples of how access can be facilitated in practice, but either party can complain to the CAC about a breach of the agreement or interference from a third party. The CAC can vary the agreement and declare a complaint well-founded or not, and order specified steps to secure compliance with the access agreement. But the real teeth in this are, and I think the thing that employers, will want to be mindful of and will want to pay interest to, are the penalties. If there's a well-founded complaint about repeated breaches of access agreements within 12 months, or a CAC order is breached, the current plan is for the CAC to be empowered to impose really significant financial penalties. I mean, certainly they're going to be significant for some employers, up to 75,000 for a first order made by the CAC if there's been a breach, up to £150,000 for a second order made by the CAC for a breach of an access agreement, and up to £500,000 for a third or any subsequent order made by the CAC regarding the access agreement. Now, the amount will depend on factors including the gravity and the duration of any breach, the reason for it, how many workers are affected, and the employer's size and resource, and also if there's been any previous failures. But obviously, you're going to have wide-ranging access applications. You're going to have a number of different sized organizations, number of different resource organizations that are going to be getting these requests. And if there is a failure to comply, some of those numbers could really impact an organization, materially, if you're talking about £500,000.
Thanks, Stuart. That does sound pretty impactful for employers. So why should employers be particularly alert now?
Well, I think Stephen alluded to this earlier, but timing is tight, so that you don't have some of the timescales involved in what's being proposed here are really short. Response and negotiation periods are short, and employers are going to need to be able to identify these requests quickly, assess legal and operational risks, and then they're going to have to take legal advice definitely in the early stages of when these new regulations are in place and this new rights in place. So it's something we need to be paying attention. Employers need to be paying attention to now. And I also think a number of employers that would traditionally be thinking to themselves, well, we don't have to worry. We're not an industry that we have to worry about unions. It's not something that's going to impact us. We're not a traditional unionized industry. That's not the case anymore. I think everyone's going to have to start thinking about this, especially with the penalties that are involved, because the stakes have just got a lot higher. Once a union has a foothold in your organization, they're going to be able to speak to your employees, and they might always be complimentary, and you might find that you've got to react to that and take some steps in response to that.
So with all of this in mind, what do you both think the key takeaways are for employers?
For me, it's about focusing on employee engagement, taking the temperature on employee satisfaction right now. If there are any niggles or any areas of discontent, try and sort those out now, so that any union that does get an access right has less to persuade people over, less to try and convince a workforce that changes need to be made. And then the other thing I think that's really important is reviewing how you go about consulting with your workforce, how you're giving them information, how you're getting information from them, and you're dealing with that consultation process.
Yeah, these are really important points, Stuart. And Charlotte, another point that's worth emphasising is for those organisations who already have a recognition agreement in place, And it's worth remembering recognition agreements are not necessarily written down on paper, they may be de facto recognition. If you're in that situation, you might want to add to the recognition agreement some form of voluntary access with the existing union, because as I said earlier, that's a ground on which the CAC could refuse the new access request, which is coming in from a competitor union. And actually, another point, this is probably self-evident, from the 15-day timescale. But if an approach is made by a union, remember, it doesn't even have to be in writing. If an approach is made, the organisation is going to have to take advice promptly. And I think a real danger, and what the unions will be looking for, is that blanket or knee-jerk refusal, as just a straightforward no, because that would show, obviously, there's no intention to come to some kind of accommodation. And make sure that HR and other senior colleagues know the rules and the importance of following them. And if I could add one more point, I would say that it would be sensible to have an operational plan ready for responding to an access request. So when it does come in, everything's in place. We know what to do in addressing the request and taking advantage of the limited exceptions that apply. And I suppose worth saying that Stuart and I are available in the event that any advice is needed either about the current employee engagement activities or drafting an operational plan to respond to this important new statutory right. Stuart, I don't know if you want to say anything about the code of practice which Charlotte mentioned earlier.
Yeah, well, the finalised code of practice and the supporting secondary legislation were laid before Parliament on the 6th of July, and subject to approval, are expected to come into force on the 30th of October. So also look out for any updates that we'll be delivering over the coming months around that, when that is finally approved.
Brilliant. Well, thanks, Stephen. Thanks, Stuart. I think that's plenty for employers to be thinking about. And please do get in touch with us if you've got any questions that you'd like to discuss with us on this topic.
Thank you.